Hello, my name is Jingo Nelly, and today we are going to be looking at another tutorial. But before I begin off, make sure you subscribe to the channel. It will bring you some good luck in your forthcoming exams. So looking at the board of directors, so this is another organ that is charged with the management of a company, and with this they largely exercise the general policy control of the company. So the detailed management of the company can be left to the managing director or the chief executive officer of the company. So what the board of directors does, it delegates its functions to like a single managing director, the one who's going to carry out the detailed management of the company. So there is no definition of a director in the Companies Act or even under case law. So they're saying under section 1 of the acts, it states that a director includes any person occupying the position of a director by whatever name he may be called. So that is with that. It has no definition. So moving on. So with the board of directors, they have almost absolute power to bind the company, especially when they are acting in good faith. But there's an exception where their power is limited under the memorandum and the articles. So shareholders, however, they have the right to sue the board of directors to retain it from doing an act which is beyond the powers of the directors. So that is with that. Moving on. So before I go further, let me look at the categories. The categories of directors, but you should note that it is not a must for a company to have directors, but it is just a common practice that every company is doing it. So under the category of directors, I can look at the de facto directors. Who is a de facto director? This is a director who's appointed, or this is a person who is appointed as a director, but does not fulfill the qualifications of a director, but takes on the responsibilities of a director. For example, if at all one is to be a director, he must fulfill a qualification, like the qualification is to buy shares in order to be a director. So for you to be a director of a particular company, you must buy shares. So if this person does not buy the shares, but he acts as a director, that person can be called a de facto director in law. Now, these are not English terms. Yeah? So we're having the de jure director. This is the opposite of de facto. So de jure is the opposite. So for de jure director, this is a person who is appointed as a director and has fulfilled the qualifications. Then another category having the executive and non-executive. Now for executive directors is one engaged in the day-to-day runnings of the company, and these ones they act as employees. They can be like employees of the company because for them they sit at the company premises and they are supposed to be paid. Or in other words, they are paid. And we're having the non-executive directors. So these ones they only attend meetings. Yeah. So that is with that. So looking at another category, that is the nominee director and alternate nominee director. So for the nominee director, let me look at section 186. So for this, a single member company is required to appoint two nominees, one of who becomes a nominee director in case of death of the single member, and the other becoming an alternate nominee director to work as a nominee director in case of the non-availability of the nominee director. So this is basically looked at under the single directors under the single member companies. So directors under single member companies, I told you, we're having the nominee director and the alternate nominee director. If I told somebody is a single member, is in a single member company, supposed to nominate two directors. So for the nominee director is the one who is the person who acts as a nominee director in case of death of the single member and for the alternate nominee is the one who works as a nominee director in the absence of the nominee director. That is the alternate nominee director. So you, after knowing that, maybe I can look at what the nominee directors are meant to do. They're meant to transfer shares to the legal heirs of the single member. They're supposed to call the general meeting of the members to elect the directors. They are supposed to manage the company affairs in case of death of the single member until the transfer of shares. They're supposed to inform the registry of death and provide particulars of the heirs. So a single member or a member of the or a person who is having a single member company does not normally pick any person. So he picks people that he can trust, that they will fulfill the duties and they transfer the shares to the heirs in case of anything. So that is with that. Then I'm going to the qualifications of directors. Now with the qualification of directors, I'm having he must have consented to act as a director. That is requires that before a person can be appointed as a director of a company with share capital, he must have signed and delivered for registration of his consent to act as a director, and he must have signed the memorandum of association for his qualification share. Now, this it's there. It's a qualification of the directors, but it's not a must here. Nowadays, these guys don't do it. Yeah, but it's a point. The exam you're supposed to put it, but in actual sense, when you come to day-to-day life, sometimes these guys don't apply this. So, looking at another one, he must be aged above 18 years. So here, for a person to be appointed as a director, he must have obtained a minimum age of 18 years. Then he must not be an undischarged bankrupt, like maybe previously he may have failed to pay, or he may have they may have discharged him as a bankrupt. So this person is not does not qualify to be a director. And if at all this person does become a director, he must pay a fine of 100 currency points, or he goes to prison for 2 years, or he can do both. He can pay the fine and also go to prison for 2 years. Then we're having another one. A person convicted of the following offenses can't also be a director. An offense connected with the promotion or formation of the company, if during the winding up of any other company that person was convicted as an offense relating to fraud. You get it? When they were closing off the company, this person did some things that weren't proper with the law, that is to do with fraud, or if the person has been guilty of all breach of any duty to a company in which he was a director. So all those offenses, that person is not qualified. So we are having the share qualification, where a share qualification is a requirement for one to become a director. So the shares should be taken up within the 2 months from the date of appointment. Otherwise, the director must vacate the office. So here, it's to do with the qualification. Like if at all for one to be a director, he must have paid the qualification share. So that is with that. Then here, okay, I'm moving on. So here I'm going to be handling some case whereby it looks at the acts of persons who act as directors when they are not qualified are not necessarily invalid. So here they are saying that in case a person acts as a director, and yet they are not qualified, like they have not given their share qualification. It's not necessary that it is invalid, yeah, or they are not liable. So we have a decided case already here, a case of RV Camps here. So in this case, the articles required every director to hold in his own right at least one fully paid up share in the company, or in the capital of the company. So Camps did not satisfy this requirement but continued to act as a director. Remember the category of directors that I hint on. So this guy, for one to be recognized as a director, he must have paid the share up capital, fully paid up for a share, uh, in the company. So when he was charged with failing, with failing to keep proper books of account, and also failing to hold an AGM, and also failing to produce the accounts and the balance sheets, the accounting guys, so he agreed. He argued that he wasn't even qualified to be a director. So what happened? The trial court held that since Camps never acquired his qualification shares, the trial court, his appointment was invalid, and the case was dismissed. You get, yeah? So the state appealed and went to the Supreme Court of Kenya and argued, and the Supreme Court agreed with the trial court and held that Camps could not be held to be a director. They pointed out that, so in that they agreed with the trial court, could not be held to be a director, since with the enactment of the section which was made which made it an offense to act as a director when unqualified. They're saying the legislature did not intend to include such persons as Camps. So he was like, fine, Camps could not be held to be a director, since with the enactment of the section which made it an offense to act as a director when unqualified. So it was an offense to act as a director when you're not qualified, like you didn't have the paid up share capital. So the legislature did not intend to protect such people as Camps, because they're not qualified. They should do and they act as directors. They should just go away with it. You get, and they're not liable. So this is when the other categories come in: the de facto and the de jure director. So the state appealed further, and it was held that Camps had been validly appointed as a what? A de jure director. So in brackets, we having that is, he wasn't a director as a matter of law. He had not been appointed validly as a de jure director. Remember, this is what the trial court and the Supreme Court agreed on. Fine, he was not validly appointed as a de jure director, but he continued to act as a what? A de facto director. That one who acts that one as if he is in fact a director, and therefore was liable. Remember, I already gave you the definition of the de facto director. So the court pointed out that any person who performs the functions of a director, though not duly qualified, is occupying the position of the director, though not duly qualified, is occupying the position of the director, that to hold otherwise could be to defect the object of the penal sanctions relating to the liabilities of directors. So all in all here, what court summarized in was saying that this guy is liable. Camps is liable because he appealed to be a de facto director, and he was liable for not presenting the accounts, for not presenting for not doing proper books of account, of failing to hold the AGMs and stuff. So this guy, he was liable. Yeah. So the court did he did not go away with it as he thought. So that is it. Next we shall be looking at the payments of directors next time.
Thank you so much for watching. Make sure you subscribe to the channel.